Get ready. 3 seconds. 2 seconds. Start. In my opinion, the learned SDJM has improperly exercised his jurisdiction in passing the impugned order. A magistrate who, on receipt of a complaint, is empowered by Section 156 (3) CRPC to order a police investigation where he does not himself issue process at once. This power can be invoked by him even before he takes cognizance of the offense. If the police, after investigation, submitted a final report recommending discharge of the accused on the ground of insufficient evidence, the magistrate is not bound to accept the final report. But after forming an opinion on the police report which states that no case was made out against the accused, may nevertheless take cognizance even on such report if there are materials for taking cognizance of an offense. In other words, a magistrate, even after accepting the FR, can still take cognizance of the offense upon a complaint or protest petition on the same or similar allegation of facts. Section 2 (d) CRPC defines the term complaint to mean any allegation made orally or in writing to the magistrate with a view to taking action under the code that some person, whether known or unknown, has committed an offense, but does not include a police report. The expression protest petition will thus come within the purview of the term complaint if it satisfies all the ingredients mentioned in the section 2 (d) CRPC. Therefore, it can now be taken to be the law that whether a protest petition is treated as a complaint, the magistrate will have to proceed in accordance with the procedure laid down in Section 200, 202, and 204 CRPC. Section 190, however, sets out the different ways in which a magistrate can take cognizance of an offense. That is to say, take notice of all allegations, disclosing commission of a crime with a view to setting in motion to bring the offender to book. Therefore, where initially the complainant had filed a complaint before the magistrate under Section 190 (1) (a), but the magistrate forwarded the complaint to the police under Section 156 (3) for investigation, as in the case, and where the police, after investigation, returned the case in FR on the ground of insufficient evidence. If the complainant nevertheless wants to protest, he is thereby inviting the magistrate to take cognizance under Section 190 (1) (a). If it were to be so, the protest petition so filed shall have to satisfy the requirement of a complaint as defined in Section 2 (d) CRPC, and that the complaint should contain allegation of facts which constitute an offense or offenses upon which alone the magistrate can take cognizance under Section 190 (1) (a) CRPC. Even a bare reading of the protest petition reproduced above will show that the statement made therein do not contain any allegation of facts which can be said to constitute an offense punishable under the law. What the respondent number 2 said therein is to express her dissatisfaction with the manner in which investigation was carried on by the police, which resulted in the submission of the FR, and that she wanted to continue the case as a complaint and had other witnesses. That is all. The first learned SDJM did not pass any order to this FR, but proceeded to register CR case number 1269/2011 on the basis of the said protest petition, and had examined the respondent number 2 and four other witnesses, and was said to have found a prima facie case under Section 143/436/427 IPC, and committed the case before the learned session judge, as Section 436 IPC is exclusively triable by the Court of Sessions. The learned additional session judge Kamrup, before whom the case was ultimately made over, noticed that the learned SDJM did not pass any formal order on the said protest petition. He therefore remanded the case before the learned SDJM Rangya, who ultimately passed the impugned order. On receipt of the record, the learned SDJM accepted the FR and dropped the proceeding, but in the same breath held that his predecessor, vide the order dated 19/9/2010, has treated the protest petition to a complaint petition, proceeded with the same, and then took cognizance of the offences punishable under Section 143, 436, 427 IPC against the petitioners, and as such, the complaint case number 1269/2011 should proceed from now onwards. He then directed that the record be resubmitted before the learned additional session judge. The least I can say is that the learned SDJM apparently did not even bother to peruse the contents of the protest petition and try to refer the provisions of Section 2 (d) 190 (1) a of or 200 CRPC. For the reasons stated in the foregoing, this revision is allowed. The impugned order dated 23/11/2012, passed by the learned Subdivisional Judicial Magistrate, is hereby set aside. The consequential proceedings, if any, shall also stand cancelled. The judgment shall not, however, preclude the respondent number 2 from taking up fresh legal proceedings against the petitioners in accordance with law.